Good morning. My name is Richard Thorpe. I am chair of Panel B for the Medical Board of California, and we're preparing to get started with our morning session. Good morning, Judge Larson and Mr. Peters. We appreciate your joining us this morning.
Morning.
I really don't have, the only thing we need to do is just call the meeting to order and call the roll and establish a quorum. So Van, could you, we'll call the meeting to order at 9:03. And if you could call the roll, sorry.
Dr. Ayla Rodriguez,
Here.
Ms. Lawson,
Here.
Dr. Mahmood,
Yes.
Dr. Thorpe,
Here.
Dr. Yip,
Here.
Ms. Rimke. All right, we have a quorum.
Thank you, Van. I appreciate your help with that. I think we're ready to proceed with the first case, Dr. Brad Penenberg, and we can, I'll ask Judge Larson to go ahead and begin the formal proceeding.
All right, thank you. All right, the first thing I need to do is to make sure that Dr. Penenberg is here and that I'm assuming he's in person there with you. Yes, there we go. And also his counsel, yes. And that's Mr. McMahon, correct?
There we go. Yes, Your Honor. It's very nice to make your acquaintance.
Right, good morning. And then also the Deputy Attorney General. Also, I want to make sure that I can also hear Mr. Mejia. Yes.
Good morning, Your Honor.
Good morning. All right. So in just a moment here, we will get started. Mr. Peters is our court reporter. What we will do is I will ask him as soon as he's ready. We'll go on the record. I will announce the case. I will have the parties announce themselves for the record. I will have each panel member announce themselves and establish a quorum. I do that for each hearing. And then I will go over the procedures on how the oral argument will proceed this morning. All right. All right, Mr. Peters, as soon as you tell me you are ready, we will get started.
I am ready whenever you are.
All right, on the record. Good morning. We are on the record before the Medical Board of California, Panel B, Department of Consumer Affairs, State of California, in the matter of the accusation against Brad Penenberg, Dr. Brad Penenberg, MD, physician and surgeon certificate number G58794. This is Medical Board case number 800-2018-050663. OAH case number 2022-080-466, period 1. Today is Wednesday, March 14th, 2025. It's 9:06 a.m. This is the date, time, and location of the notice of oral argument after a non-adoption of a proposed decision. We are conducting this oral argument in person. The parties are in person, and I am on WebEx. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. I'm going to first ask each of the panel members to identify themselves for the record and establish a quorum, starting with our board chair.
Richard Thorpe. Thank you.
All right, and then continuing with our vice chair.
Hi, the vice chair, Christina Lawson.
And then continuing Dr. Ayla Rodriguez.
Dr. Irving Ayala Rodriguez here.
All right, and Dr. Mahmood.
Dr. Asif Mahmood here.
And Ms. Rimke. Ms. Rimke is she not here? I'm sorry.
Ms. Remke is absent, yes.
All right, Adjournment. There we go. And then Dr. Yip, yes.
Yes, Dr. Felix here.
All right, and we do have a quorum. Right. I'm going to now ask the parties to please state their appearance for the record, starting with the Deputy Attorney General.
Giovanni Mejia, appearing on behalf of the Executive Director of the Medical Board, Reggie Varghese.
And counsel for respondent.
Good morning, everyone. My name is Raymond McMahon, and I represent Dr. Brad Penenberg, and Dr. Penenberg is present as well.
All right, good morning.
Morning.
Good morning.
So the way the oral argument will proceed this morning is respondent.
Do you want me
Oh, I'm
to
sorry.
identify the court reporter?
Oh, I'm sorry, Mr. Peters. Yes, please state your name and your CSR number. Thank you for the reminder.
My name is James Peters and my license number is 10,063.
Thank you. All right, the way in which the oral argument will proceed this morning is as follows. Respondent has 15 minutes for opening argument. The Deputy Attorney General then has 15 minutes for opening argument. Respondent then has 5 minutes for closing argument, and the Deputy Attorney General will then have 5 minutes for closing argument. These time limits will be strictly enforced. I am timing, I will have a timer and I will be monitoring the time. And for the opening argument, I will give each party a 1-minute warning. And for the 5-minute closing, I will give you a 30-second warning. As a reminder, the board has already has the benefit of reading your briefs. The oral argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or a panel member may ask a party to support the party's oral argument on a matter with specific citation to the record. At the end of the oral argument by counsel, I will offer Dr. Penenberg an opportunity to address the panel if he wishes. If he elects to do so, I will place him under oath. As you know, Mr. Peters, our court reporter, is present and he is transcribing the proceedings. So it's important during oral argument to please keep your voices up and speak a little more slowly than you would in a conversation. After the conclusion of the 2 oral argument hearings we have this morning, the board will go into closed session to deliberate. The parties will not receive his decision today, but will receive a written decision sometime in the future. All right, with that explanation, is there any questions from the parties?
No, Your Honor.
No, Your Honor.
All right, then with that, I will start the timer and then tell respondents at counsel, Mr. McMahon, when you can proceed. Right, you may begin.
Thank you, Your Honor, and thank you, members of Panel B. It's my pleasure to be here in front of you. Actually, I'm very happy to be in person in front of you. It's nice to be able to do that, and it's a real sincere pleasure representing Dr. Brad Penenberg. Dr. Penenberg is, as the record reflects, and as you are aware, an exceptional surgeon. He's preeminent in his field and is a specialist in treating complex knee and hip replacement procedures. He is published in various peer review materials. He has numerous patents. He has been an exceptional physician for 35 years. This is the first time that he's been subject to this type of a matter. And the matter we're talking about occurred in 2017. Dr. Penenberg is one of the top orthopedic surgeons in the nation. And the care that he rendered in this case was entirely appropriate. As reflected by Judge Montoya's decision, the overwhelming evidence supported that there was no unprofessional conduct that had been provided in this case. The complainant's theory, which I believe really is one general theory, that is an allegation that Dr. Penenberg did not appropriately work up this patient preoperatively. And the record does not reflect that. In fact, the record is exactly contrary to such an assertion. In this case, The patient was under the care of a nephrologist, Dr. Mamani, and had been under the care of the nephrologist for quite a few years. The patient had already undergone 1 knee replacement surgery. The patient complained significantly of impact on his quality of life because of the severe pain because that surgery failed. Dr. Brahmani, knowing the patient's medical condition, knowing that he had had chronic renal failure for 5 years and had been on dialysis successfully and stably for that time frame, referred the patient to Dr. Penenberg for a knee replacement surgery. Dr. Bhamani, who testified in this hearing, specifically testified and accurately testified that she does not give preoperative clearance for a patient. She does not expect to give preoperative clearance, and she's never asked to give preoperative clearance. She knew the patient was going to be undergoing the surgery and, in fact, referred the patient to Dr. Penenberg. Those facts are not, they're not challengeable. Those are the facts. Dr. Penenberg, who is the director of arthroplasty at Cedars-Sinai Medical Center, a major tertiary care facility, which you're all very familiar with, initiated the appropriate preoperative workup consistent with Cedars-Sinai's guidelines. That workup first involved medical clearance by internist Dr. Ashaya. Dr. Ashaya was very familiar with the patient's condition and had been treating him for years, knew about the patient's cardiac history, knew about the patient's renal history, and his overall health. Dr. Ashaya saw the patient originally on November 3rd, 2017 for clearance for this patient, with the surgery having been at that point scheduled for November 14, 2017. Dr. Ashaya evaluated the patient, found the patient to be stable for surgery. He did some blood work on the patient, found that the blood count was low, and had the patient admitted to a different hospital on November 7th and November 8th for transfusion of blood. At the end of that, on November 8th, Dr. Ashaya cleared the patient for surgery. Dr. Ashaya did not order that there be any lab work done 24 hours or 48 hours or 12 hours before the surgery. Dr. Ashaya cleared the patient. The surgery was set for November 14th, but the patient came in. Dr. Penenberg appropriately evaluated the patient and realized that the patient was not a candidate for surgery at that time because he had an abrasion on his knee. Had the surgery then need to be rescheduled, and it was scheduled for December 5th. Dr. Ashaya's clearance was within the 30 days. November 8th is when his formal clearance was for this, meeting all guidelines. And I again want to emphasize Dr. Ashaya, knowing when he did his clearance on November 8th, he did not ask for labs to be done on November 12th or November 13th or November 14th when he anticipated the surgery would go forward. Now, thereafter, Dr. Penenberg went above and got clearance from another internist, a board-certified cardiologist, Dr. Geft, who saw the patient on December 4th. Dr. Geft, a cardiologist, cleared this patient for surgery the day before surgery. Dr. Geft, knowing the patient's history, did not order any lab studies, did not recommend any additional lab studies, and in fact cleared the patient. The patient then presented on December 5th for the surgery, and as you're aware, was cleared for surgery by the anesthesiologist as well, who found him to be a stable candidate for the surgery and monitored the patient for the surgery. In this case, we have 3 separate clearances for this patient for this surgery. And we also have Dr. Penenberg clearing the patient from an orthopedic standpoint from this surgery. 4 surgeons involved in this care. The surgery itself was done beautifully. There was no problem. This patient did not have a cardiac event during the surgery. And in fact, post-operatively, the patient for the first day had no evidence of any problems whatsoever. It wasn't until the following day when the patient suffered the sudden cardiac event in the morning. Now, this patient was appropriately cleared for surgery. It is improper and against the law and contrary to law to say that the orthopedic surgeon who does not have the training that the internist and even the anesthesiologist who evaluated this patient was somehow to realize they were wrong and then supersede them and order additional lab studies. That's not real. That's not the way medicine is practiced. And no surgeon, no doctor should be held to such a standard. This patient, the board's expert, who respectfully does not have the level of experience dealing with complex patients like this, misunderstood and misrepresented the patient's underlying condition and found this patient to be medically unstable for the surgery, despite all the workup that was done, despite all of the pre-op clearances that were done. And he claimed that the patient was medically unstable based upon a review of a previous list of past medical conditions that the patient had, which he identified 49 conditions, which is not true. And we went through those in the hearing that their expert believed made the patient medically unstable when he knew, in fact, they weren't. For example, and I'm trying not to talk too fast, Madam Reporter, but I can't help myself. For example, sepsis had been listed in the patient's past medical history because he had been septic a long time in the past. Dr. Kashigian, the board's expert, found that to make him medically unstable. Chest pain, he said that the patient had a history of chest pain, which made him medically unstable. That patient did not have chest pain anywhere near the date of the surgery. Controlled hypertension, he said, made the patient medically unstable. Not true. But what is really fascinating, and I think from a medical perspective, is something to really consider. This patient had failed kidneys, failed renal function, chronic failed renal function. His kidney condition was not unstable. It was stable. They were not functioning. The only thing that was necessary was for peritoneal dialysis to occur. And as long as the patient was getting the dialysis, his renal status was not unstable. It was stable and had been stable for 5 years. Dr. Kashigian, in fact, acknowledged that. And in this case, the evidence, the only evidence in the record, and this came from Dr. Kashigian himself, was that the patient had been reported by Dr. Bamani, the nephrologist, to have had dialysis the day before the surgery. So we have a really truly stable, when you think about it from a medical standpoint, a stable, not an unstable patient. And the proof is in the pudding. The patient did very well during the surgery, had no problem whatsoever. I love doctors, I truly do. And it's my pleasure representing doctors, and I don't like to cast aspersions towards any doctors. But if you look at the record and look at the facts of the case, I need to point out one thing first. There's no criticism of my client with respect to any of the care after the surgery, after the start of the surgery. All of the criticism is pre-procedure. What really happened in this case is that following the surgery, the medical team did not respond to this patient. And the attending physician was contacted by the nursing staff several times during the day after the surgery and did not respond. This patient did not have dialysis after the surgery. The nephrologist was contacted at 11 o'clock at night following the surgery and advised of this. The nephrologist did not order dialysis. At Cedars-Sinai, dialysis can happen within an hour, and it was not ordered. In fact, there were no orders placed other than lab work to be done the following day and the following morning. That's what happened in here. This is not Dr. Penenberg, who his actions didn't lead to the passing of this patient. And sometimes, unfortunately, patients pass, and I don't like to talk about a person's passing in any manner of disrespect or not to give the credence that every human being deserves. But Dr. Penenberg did not commit unprofessional conduct in this case. He is the doctor I would want to use. He is the doctor that handles the most complex patients in America. And he has done this successfully for 35 years. And he's done this for the last 7.5 years from these events. Everything that Dr. Penenberg did in this case was consistent with the standard of care, in fact, was above the standard of care, and was consistent with the process and procedures in place from Cedars-Sinai and with the entire medical team. This was care that was well rendered. And from an orthopedic standpoint, everything was done beautifully. And while we all like to say, and I hate this thing called the captain of the ship because it's not true. And I was speaking with Dr. Penenberg. It's as if you blame a quarterback for a wide receiver dropping a ball, or for a running back fumbling the ball, or you blame a quarterback because when the defense is on the field, they allow a touchdown to occur. The captain of the ship has no real application in science, in law. It's not a fair thing. You cannot say, because he was the surgeon, he is ultimately going to be responsible for every aspect of the care, and he needs to have the knowledge to overrule and contest what everybody said. If what the complainant was, the complainant's arguments are there was an inadequate workup, which is not true. The complainant's argument is that lab studies had to be done within 48 hours of this. On that point, Dr. Kashigian testified that potassium levels can change very quickly on a patient who has renal failure. And he said in half a day they can change dramatically. And then he went on to say even quicker than that, they can change. Doing lab work 48 hours would not have changed this situation at all. Doing lab work 72 hours. We don't know that doing lab work 24 hours. We don't know any of that. That's not a basis for finding my client to have committed unprofessional conduct on that. And just think of the burden that you would be imposing on all of the hospitals that they require lab work within 24 hours before these types of procedures. That's not going to work. And you're going to have canceled case after canceled case after canceled case, which is going to cause tons of problems for the public. This is not a fair way to look at my client's situation. The medical board's expert indicated that Dr. Brahmani had to give medical clearance. That's not true. That's just simply.
1 minute.
Dr.
1
Brahmani
minute.
would agree with that. I'm going to go back to the last point, which I'm not sure why we're here. I don't know what point that the panel had an issue with the judge's decision, but I hope it's not the following, because there was an artifact in one note from a template which said no medical history, no past medical history. And the note from Dr. Penenberg is very comprehensive about the patient's past medical history, despite that one bit of artifact. Please don't say that that's an inadequate medical record and hit my client for unprofessional conduct on something like that. That's no doctor, none of you, I promise, and I would represent every one of you, none of you would survive that level of scrutiny. And so I'll finish now. If there's any questions, I know we're going to have 5 minutes, but with that, I submit.
Thank you. All right, Mr. Mejia.
Thank you, Your Honor. And
I'm going to hold on just a second. Let me start the timer. All right, you may begin.
thank you. And I also want to thank the members of the board for giving me this opportunity to appear before you and discuss what is a case that explores a very important fundamental issue, which is the responsibility that a surgeon bears over the well-being of his patient. Now, the accusation, the testimony of the board's expert and board-certified orthopedic surgeon Harry Kasigian, complainant's arguments throughout these matter, they stand for what should be a non-controversial principle that a surgeon performing a surgery on a patient with significant medical ailments, everyone agreed in this proceeding that this was not a healthy patient. This is a patient with significant medical ailments, must at all times exercise due clinical care and judgment in the lead up to the procedure. Now, respondents trying today, and he tried during the hearing, to provide an alternative vision that unnecessarily and dangerously allows a surgeon to indulge in assumptions about a patient's health and about a patient's care, even though there are already objective measures to ascertain what the patient's state is, especially a patient like the one in this case, in the lead up to a surgery. Unfortunately, the proposed decision endorses this view. And this is a view that's inconsistent with concerns of patient safety and inconsistent with the standard of care for orthopedic surgery. Even in the face of expert consultation, which, to be clear, complainant and his expert during the hearing testified, it is great to get specialist input on a patient, especially one as complex as the patient in this case. However, that doesn't justify blind reliance on that consultation, and it doesn't suspend the surgeon's responsibility to exercise due clinical judgment. We also know that information about a patient's past medical history, both their course of conduct, as well as the care they have received, is of course a part of the patient profile and understanding that patient's conditions. But that shouldn't allow unmerited assumptions about the current state of a patient's health at the time of a procedure. Finally, respondents' position in this case reveals a cavalier attitude towards the importance of medical record keeping, which is an essential component of ensuring continuity of care and safe treatment for any patient. Public protection and the standard of care for orthopedic surgery in this case was clearly and convincingly established to have included 3 key components in which respondent was grossly negligent. First, there was this failure to assume proper responsibility over the patient's stability in the lead up to the December 5th, 2017 revision total knee replacement. There was a failure to conduct adequate preoperative evaluation of the treatment, including obtaining laboratory testing for this particular patient with his medical profile within 24 hours of the procedure. And there was the failure to take due account of the patient's complex renal medical history and his complex cardiac history and the way they interplayed by failing to consult with the patient's nephrologist, who, to be clear, was not aware about the December 15, 2017 surgery date. She was aware of the November 14 surgery date, and she had never, her testimony is clear in this matter, she was never informed, did not learn about the December 5th, 2017 procedure until 11 p.m. that night after it had already been performed. The evidence is also clear that respondent maintained an inadequate initial evaluation of the patient that confusingly does document that the patient has no medical history, even though it is clear that the patient had a complex history of cardiac and kidney ailments, on top of other ailments such as a history of bipolar disease, diabetes, hypertension. And with respect to the stability of this patient in the lead up to the surgery, it's important to note that there's no dispute in the record that this patient had medical conditions that required chronic medical intervention in order for his condition not to deteriorate. The experts and respondent agreed that monitoring the patient's potassium level in the lead up to the surgery was critical and important because elevated potassium can lead to cardiac arrest, as unfortunately happened in this case. There's no dispute that this was a patient with end-stage renal disease, that is non-functioning kidneys. And although respondent would posit that that means his condition was stable insofar as non-functioning kidneys can't get any worse, it just beggars belief that that somehow discounts Dr. Kasigian's appropriate insight that this is a patient whose condition, because he has non-functioning kidneys, because he has a history of cardiac disease, this is a patient whose health can shift very quickly. And even respondent in his testimony acknowledged that potassium levels can become abnormal within a matter of hours, several hours. This is the context in which Dr. Kasigian spoke about this patient being unstable. And this is the context, this is the medical history, which is not in dispute in this case, and the state of the patient's health in December 2017. And it's the bedrock of the clear and convincing evidence that supports Dr. Kasigian's articulation of the standard of care in this case. And so that involved exercising critical judgment when he received Dr. Ishaya's preoperative evaluation, as well as the cardiologist evaluation the day before the procedure and anesthesiologist evaluation the morning of the December 5th, 2017 surgery. It's important to note that Dr. Ishaya's evaluation was completed in contemplation of a November 14th, 2017 surgery date. That surgery was postponed and moved back 3 weeks. Dr. Ishaya found that the patient was significantly anemic and ordered a blood transfusion on November 7th in anticipation of a November 14th, 2017 surgery date. Given what all the experts, what all the witnesses agreed about the state of the patient's health and the ability of that state to shift rapidly, it was not appropriate to blindly rely on Dr. Ishaya's stale preoperative evaluation on December 5th, 2017. We also know that with respect to the cardiac evaluation and the pre-anesthesia evaluation, those are evaluations necessarily limited in their scope to those physician specialties, that is cardiology and anesthesia, evaluating whether the anesthesia to be applied in the procedure is suitable for the patient and the risks of that. Those were not general preoperative evaluations. We also know that on the face of those evaluations, which was really Dr. Kasigian's contention, not that it was improper just to rely or receive this information, but on the face of those evaluations, the cardiologist and the anesthesiologist were themselves relying on stale labs from July of 2017, nearly 5 months prior to the December surgery date. There is no dispute in this case that the patient's health could have changed dramatically between those 2 points of time. And in fact, we know that the July 2017 labs, for example, have hemoglobin values of about 10.5, low, and possibly attributed to the fact that the patient was an end-stage renal disease. But by the time you get to the November 2017 labs, the patient's values are now being reported in the high 7s, low 8s, so a drop of about 25%. Drop that's not explored anywhere in the medical records and not addressed, especially for a patient about to undergo the rigors of an orthopedic surgery. It is in that context, and it is with those considerations in mind, that respondents' reliance on these specialist evaluations was an abrogation of his responsibility to exercise his own independent clinical judgment and understand the deficiencies in what was being reported to him. And it is in this context of a patient with an unstable health situation, insofar as his health without chronic medical intervention can change rapidly, that it makes sense the standard of care would have required laboratory testing for this patient within 24 hours of the procedure, as Dr. Kasigian wrote in his expert report and testified. Yes, there's no guarantee that that laboratory testing would have shown any abnormality or caught anything, but this is a patient with chronic medical issues that invite the possibility that he may have deterioration in his levels of electrolytes, such as potassium, quickly. The standard of care required getting as up to date as possible a picture of the state of the patient's blood and electrolyte levels. Now, the patient's unique medical history also informed the need for nephrology consultation with respect to this patient. And we know, for example, that yes, dialysis was delayed after the surgery was performed, and that was in part because the nephrologist was not aware of the December 5th, 2017 surgery. We also know after the fact that the patient did not appear for his November 2017 regular monthly appointment with the nephrologist. These were critical components in the overall medical profile of the patient leading into the December 5th, 2017 procedure that should have informed the thinking and the approach to the procedure. And notably, I also want to point out that something that respondent has at various times suggested or hinted at, that somehow Dr. Kasigian, complainant's position, would rule out any kind of relief for this patient. And that is that Dr. Kasigian, in his expert report, agreed with Dr. Penenberg that the revision knee replacement procedure was indicated. He also testified and agreed that expert consultation is good and appropriate when properly weighed. This is not a situation which complainant is saying that an orthopedic surgeon has to take over other elements of a patient's care or has to overrule other elements of a patient's care. It's simply that an orthopedic surgeon needs to exercise his critical judgment when receiving information from other healthcare providers and evaluating how to proceed with orthopedic surgery. Now, a proposed decision errs in a few respects in terms of reliance on Cedars-Sinai guidelines for a determination of what the standard of care was for Dr. Penenberg as an orthopedic surgeon. Notably, the decision is of two minds with this. At one point, it talks about these guidelines don't define an orthopedic surgeon's clinical judgment, but then when it's analyzing the specific gross negligence that occurred in this case in pages 26 to 28, it specifically relies on those Cedars-Sinai guidelines as evidence that Dr. Penenberg complied with the standard of care. The problem is those guidelines are byproducts of facility operations that are informed by other concerns more than just orthopedic medicine, anesthesia, other units, as Dr. Penenberg acknowledged in his subject interview as part of this case, which is in Exhibit 15. That's at pages A8930 to A8931. But the long and short of it is those Cedars-Sinai guidelines, it's not appropriate to consider them standard of care for orthopedic medicine. The proposed decision also takes an ambivalent approach at evaluating a key data point that is important to consider within proper context, which is the April 2017 knee replacement procedure that was performed by another orthopedic surgeon. Now, the reason I bring that procedure up, which is not at the heart of this case and which is not fully explored in this case, is that the proposed decision, on the one hand, when evaluating respondents' failure to obtain timely labs for the patient, points out that the fact that that orthopedic surgeon in April 2017 did obtain laboratory values for the patient the morning of that procedure, that doesn't establish the standard of care. And in a vacuum, that's correct. It's a relevant data point. And for reasons we'll get into in a minute, I think it's relevant to analyzing the credibility of respondents' witnesses. But more problematically, returning to the decision, when looking at the course of care in April 2017 and the fact that the nephrologist did not participate in preoperative, did not provide a preoperative clearance, the decision seems to rely on that component as conclusive evidence that the standard of care did not require a nephrology consult. So the decision is very confused as to what we can draw from the April 2017 procedure. But here's what we can draw. We can draw the fact that respondent's expert who testified that respondent did what every orthopedic surgeon would do in this case, that was wrong. The April orthopedic surgeon did in fact obtain labs the morning of the procedure for this patient. We also know that despite respondents' assurances, Dr. Kasigian is absolutely qualified to testify about this matter. He's performed hundreds of knee replacements. He performs procedures on patients with end-stage renal disease approximately once every other week. Dr. Jankowicz, respondent's expert, on the other hand, chronic kidney disease is not a common part of his practice. So ultimately, the credibility determinations for the experts in this case in the proposed decision is wrong. Finally,
all right, time. Mr. Mejia, time. Thank you. All right. Now going to set the time for closing argument. Mr. McMahon, are you ready?
I am. Thank you, Your Honor.
You may begin.
And I'd like to thank Mr. Mejia, and I'll let you know, I know all the DAGs in this room, they're all excellent. And Mr. Mejia did an excellent job on behalf of the complainant, but he's wrong. And what I want to go over a few points that he's really wrong about, and forgive me, I don't want to come across wrong here, but remind you, the standard of care is what a reasonable doctor would do in the same or similar circumstances. That's what the standard of care is. Gross negligence is an extreme departure from the standard care, or a want of care in this case. The allegations against my client are not only they're not negligence, they're gross negligence. The burden of proof that is held by the complainant in this case is clear and convincing evidence, meaning the decision must command the unhesitating assent of every reasonable mind. Meaning, for you to find my client to have committed gross negligence, every reasonable person would have to agree with that. Respectfully, that's not possible in this case. And I want to really emphasize this point. If you find that this is below the standard of care, not to what occurred in this case, if you believe that this is gross negligence, you will be directly impacting patient care, because no orthopedic surgeon, when they read this decision, would operate on a complex patient, because they will not want to be held to an impossible standard that is not true in medicine and be responsible and face discipline by the Medical Board of California. 4 of you, I know one's a lawyer, 4 of you are physicians. It's hard to be a physician in practicing, and it's getting harder every year. This is not, you do not use the result because a patient died and then discipline the doctor who operated on the patient because common sense, which is not common sense, suggests that he or she is responsible for that. That's a standard that hurts the public. That's a standard I urge you not to take in this case. There were lab values, just to correct the record, there were lab values by Dr. Bomani in Cedars-Sinai medical records with potassium levels in November of 2017. And those are located on page A8231. They were uploaded into Cedars-Sinai's records, I think on November 24th, about 2 weeks before the surgery. These are part of the medical records, and they were there. Dr. Ashaya did not testify as a witness. Dr. Geff did not testify as a witness in this case. We don't know if they reviewed those or not, but we do know, in fact, that they were in the records and were available. Dr. Adante did not test. He's the anesthesiologist. He did not testify, but we know this was in the record. So references to reliance upon labs 6 months old, there's no evidence supporting that. We don't know what the doctors relied on. But let's say they did rely on labs that were 6 months old or months old. All of these doctors did that. Again, the standard of care is not perfection. It's not what we want as an ideal. It's what a reasonable doctor does in the same or similar circumstances. Here we have a preeminent orthopedic surgeon who teaches orthopedic surgery to the fellows, the people who are practicing for the next 20, 30 years. Dr. Penenberg is teaching them. Dr. Jankowitz teaches fellows and teaches orthopedic surgeons about the standard of care and how to appropriately work up patients at a tertiary care center. Dr. Kashigian doesn't do any of that. Dr. Kashigian, and he's a wonderful doctor. I'm not, again, I would gladly represent him. I hope he never would need me. But he does not have the level of working with these complex patients and the workup that's done, and that's undisputed. Dr. Kashigian had a total of 5 months, giving him credit for that, of training in internal medicine back in 1975.
Seconds.
Not going to set the standard of care. Again, thank you for taking time and I hope I answered your questions.
Thank you. All right, and Mr. Mejia, please let me know when you are ready.
I'm ready, Your Honor.
You may begin.
Thank you, Your Honor. And thank you again to the members of the board. I just want to address briefly that the fact of the matter is, respondent, this isn't about the adverse result that occurred here. This is about respondent's decision-making and his knowledge in the lead into the December 5th, 2017 procedure, given this patient's complex medical history. And what's crucial is that respondent didn't know whether the cardiologist and the anesthesiologist reviewed the November 2017 lab values. What respondent could see is in the evaluations themselves, the most recent lab values they had incorporated into their evaluations were from July 2017. This is about what a reasonably prudent orthopedic surgeon would have done in these circumstances dealing with this patient and with this patient's complex medical history. And touching briefly on the inadequate record keeping in this case, absolutely, record keeping matters. This patient, especially with their complex situation and with multiple healthcare providers involved, documenting accurate medical history for this patient was of the utmost importance. And crucially, during cross-examination at the hearing, respondent troublingly admitted that it was not his practice and custom in 2017 to review all of the dictated notes that came back to him for errors such as the one that occurred in this case. And that's in volume 2 of the report's transcripts at page 92. Ultimately, this case is about properly evaluating and treating and moving forward with surgery on a patient who presents a complex medical profile. Respondent failed to do that. For that reason, complainant respectfully recommends that the proposed decision be modified to 1, find that respondent committed gross negligence in the 3 respects we've discussed at length today, and that he failed to maintain adequate and accurate records for the patient as required under Business and Professions Code, Section 2266. We do acknowledge respondent has a long history of practicing without prior disciplinary incidents. We do acknowledge that other care providers were involved in this case, and for those reasons, we would recommend a minimum disciplinary term and conditions as set forth by the disciplinary guidelines, which would be 5 years probation, education courses, a medical record keeping course, a practice monitor, and all the standard terms and conditions of probation. Thank you.
Mr. McMahon, does Dr. Penenberg wish to address the board or the panel?
Yes, Your Honor, he does.
All right, Dr. Penenberg, the first thing I need to do then is swear you in. If you would please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may lower your hand. Please state and spell your name for the court reporter.
Brad Penenberg, B-R-A-D, P-E-N-E-N-B-E-R-G.
All right, Dr. Penenberg, you may address the panel members at this time.
Thank you. I appreciate the opportunity to speak with you directly. It's been a long, arduous experience over the last almost 8 years now. And I live with this case every day. I appreciate that. This is not kind of a casual experience that I could just kind of have happen and forget. Spent the last 35 to 40 years training and approaching orthopedic surgery at what I believe is an extremely high level. Trained at a tertiary care center in Boston, and we specialized in dealing with the most complex patients with multiple medical problems, patients that were turned down at other institutions because of these complex medical problems. Did fellowship training at the same institution at Mass General, and in practice, I chose to carry on that training, those experiences, that knowledge, and apply them to a career in orthopedic surgery, initially at USC and then at Cedars for the last 30 years. And I'm at Cedars because we have the subspecialty capabilities of handling these patients that other institutions prefer not to manage. And the economics of these patients can be challenging for smaller hospitals in addition to the medical challenges. I like to believe we face these challenges. I like to believe we've learned a lot from this particular case, and it illustrated a number of issues. But specifically, the medical record keeping issue, I just have to say a word. We were in transition to electronic medical records. There are templates that exist. There was one line item in the template that said no medical problems that carried through to the final note. This is not a comprehensive issue. It's one line item that I think is being magnified out of proportion. Taking care of these patients with multiple medical problems requires the input of multiple specialists. I've worked with all these people for many, many years, and we rely on their evaluations, their judgment. It's not my position to second guess a cardiologist, a nephrologist, an internist with regard to medical management. And we have to rely on each other's expertise. And this particular patient came to me, could barely take a step without severe pain. He was referred by his nephrologist. He understood all the medical issues. The patient uniquely, and it's really hard for me to believe Dr. Shagian sees these patients once a month, because it's just not the case in our world anyway. But a patient with chronic renal disease who can prove themselves to be stable. Just carrying the diagnosis does not make the patient unstable. It makes them required to undergo specific treatment on a regular basis, as is true with most medical problems. We understand and we respect that. A review of this patient's medical record over a period of a number of years indicated his renal condition was understood, managed appropriately, and could be easily managed at the time of and after his surgery. I believe that any of the pre-op issues, the concerns and the questions, I mean, could easily be raised after the fact. Unfortunately, the outcome is what has us sitting here today, but I don't believe any of the preoperative circumstances contributed to that ultimate outcome. We, again, rely on our subspecialists for both preoperative and postoperative management. In this case, we were disappointed with regard to the accessibility of the postoperative management, and I think that's the reason we're sitting here today. But we, because of that, in the whole picture of this particular case, we are have been over the last few years reworking how we obtain preoperative clearance. The term preoperative clearance has in the past and over decades been a kind of an acknowledgement that it's okay and it's safe to proceed with an operation. What's not implied in the term preoperative clearance is the fact that these subspecialists are intending to follow the patients postoperatively, diligently be there at the time of the surgery, are available and just a phone call away, which has been the case over the years. And this case illustrates that that's not always going to happen. Believe that sums up what I can say in this brief period of time. Thank you very much for your indulgence.
I'm going to now ask the panel members if there are any questions, starting with the panel chair, Dr. Thorpe.
Thank you, Judge. I do have, I mean, obviously this is a extremely difficult case. Extremely difficult case. My background is internal medicine, so I do understand the complexity of the case. I think there are a couple of things in the record that were concerning to me, in that Dr. Ishaya, in his my understanding, well, so I struggled with the case because I couldn't get through the 10,000 pages of documentation, which anyway. But
so Dr. Thorpe, I just want to remind you, if you can just focus on the questions that are relate to the record.
That is what I'm referring to, Judge, is
All right, thank you.
Dr. Ishaya's reported by Dr. Jankowitz that the patient was stable for surgery, but that he should be monitored closely. And monitoring closely to me means perioperative monitoring with the trauma of a major joint replacement. There is significant tissue injury, and there is in an anemic patient, there is some blood loss. Not you didn't have severe bleeding, clearly, but there was. So the question I had is, based on those recommendations, and also Dr. Jankowitz in his note said clearly the time for a potassium that would have been most appropriate would have been immediately post-op. And my question is, why was that not done? And I guess so that's one question. The other question I have is,
so Dr. Thorpe, can we let him answer that question before you ask the second one?
Yeah, sure.
And I don't know if I can answer that or my client should answer that or both. And I'm glad to do either or any of those.
So I want to remind everybody that the information must already be in the record. And so to the extent that it's in the record, you can answer that question. Counsel, if you don't have the answer, you can defer to Dr. Penenberg. But again, you can't add new information, right? It has to be in the record that you're referring to.
I understand, Your Honor. I'll maintain that. And I love the fact, I'm sorry, that even the panel get yelled at by the judge. So that's very nice.
No, I did not yell. I do not agree with that.
I overstated that. This is in the record, and we could get the actual page sites, but it's in the entire Cedars-Sinai medical record for the hospitalization was admitted into the evidence. Post-operatively, there were orders for Dr. Ashaya to manage the patient. Dr. Ashaya was contacted by the nurse, and there are 2 nursing shifts. The patient came out of surgery around 11, 12, 1 o'clock. I don't remember exactly what time it was. And then there were calls placed to Dr. Ashaya advising Dr. Ashaya about the patient being admitted under his care. They did not get in touch with Dr. Ashaya throughout that day. Multiple calls were placed. Shift change happened, and the calls continued to be placed. And the new ongoing nurse finally at 11 o'clock contacted, and it may have been before, or put calls into Dr. Bamaya, the nephrologist. None of this, and the records reflect this, Dr. Penenberg was not told that the nursing staff was having problems getting in touch with the attending internist covering for whom was managing the patient medically. He had no idea about this. And it's also, Cedars-Sinai is a tertiary care facility. They have residents, it's not surprising, rounding on this patient. I'm at a loss as to why the residents team didn't get involved as well and initiate that. But all of this happened in a vacuum to Dr. Penenberg's knowledge. He had no idea that the medicine team was not responding to it. And that's what happened, because the patient did need close monitoring. And that just, there could have been more robust monitoring is how I would put it, and follow up. But I will also say in this case, and I don't mean to be technical as an attorney, but the accusation against Dr. Penenberg is not post-operative at all. The only allegations of unprofessional conduct are all pre-operative. So the complainant has not presented any criticism of my client from any post-operative management. So my client, he wasn't responsible, but he legally couldn't be held responsible for any post-operative management. But I hope, Dr. Thorpe, that answers the question.
I might just say a word. The missing link is the fact that we ordered, there was an order for the interns to be called with the expectation that he would order the labs. That's our practice, and that has been the practice for many years. That they would pick up the patient at that point, order hematocrit and electrolytes, et cetera.
Yeah.
And that's the period of disappointment that the contact wasn't made until 11 o'clock that night. The patient was in recovery by 11 that morning. And that is, I think, the major issue that we're facing.
Dr. Thorpe, you had a second question?
Yeah, I did have a second question or clarification, and that is, that a complex patient clearly needs your services. You are, an eminent orthopedic surgeon and provide care to complex orthopedic problems. Comes to you with an expectation of, in spite of his severe chronic illness, comes to you in expectation of pain relief because this joint has become so painful, even though it was just recently replaced. And you provide that service, which is a benefit for sure. If you are not the person in charge of this patient, who is?
Certainly accept responsibility for being in charge of the coordination of care. And I can't make any comments with regard to his suitability from a cardiac standpoint, what the recommendations might be. From an internal medicine point of view, his hypertension, from a renal point of view, the nephrology follow-up. A reliance on, again, this gets back to an issue that I'm hyper-focused on, have been for all these years, the preoperative clearance And do I second guess an internist who has done the evaluation? I will review their findings. My physician assistants now scrutinize every lab result beforehand, and I can tell you that the level of diligence now causes us to cancel cases on a regular basis. And the scrutiny, I believe there was high level of scrutiny back then, and just trying to coordinate the specialists. And I think that is my responsibility, but not to make a comment about the opinion of our, the subspecialists that we rely on.
Thank you.
I'm going to ask if there's any other panel members who have questions, and if so, if you could just please state your name.
I have. Can I go?
Yes,
Okay.
and just please state your name.
Yeah. Thank you so much. My question is on, obviously, we're going to concentrate on pre-op. Do you have is this, the last labs were done 6 months ago or 2 weeks ago? So that should be clarified.
The last labs that with measured potassium were done in November. They were done on November 7th, November 7th, 2017. There are potassium labs in Cedars-Sinai Medical Records, and that's at page A8231.
Okay. And has there been a trend that have somebody looked at the labs that in last 6 months, how many times the labs have been drawn and how the potassium has been trending?
The labs were drawn a couple of times. They were all consistent. They were in a reasonable range. Dr. Kashigian testified himself under cross-examination, and I can give you the page numbers on that the labs were always in a reasonable range for the potassium during all of the testing. All he had to do, if the patient dialyzed, the potassium was controlled, and the patient was regular in his dialysis for years.
And doctor probably would know better. Probably, if patient was a dialysis patient, they would be checking labs more frequently than just they might not be in the records. Do you have knowledge of that? When patients go to the dialysis, usually they check spot electrolytes, and
Yes, he was receiving dialysis every other day and
Probably,
checking
yeah.
in with his internist at least once a month.
I'm sorry, he was on peritoneal dialysis, so he was doing that himself, but he was getting labs typically
Okay,
once
so
a
he was-
month by Dr. Bamani.
okay. So trend of the labs, we are sure was pretty staying normal.
Very consistent for a number of years, yes.
Okay. Okay. That set the standard. Second thing is, uh, you give the care to, and most of the time this happens. I'm a physician myself, that medicine team handles those things. And I'm not saying at all that it takes the responsibility away from you. When they were trying to call, Cedars-Sinai is one of the gold standard and it's one of the probably top hospitals. When they're calling an internist 1 time and 2 time, is there any course of action why somebody is not answering and who is responsible or any internal inquiry on that? I'm not going to bring a new evidence over here, but just trying to set the course that who was responsible for that at that time. Did they try to call you? The internist is not answering, or did they try to call any other doctor or resident or fellow or anybody?
I would typically expect a call if they couldn't reach the requested physician within an hour or two, and especially a patient with this care requirement. That's the expectation, and that they would call me. This is a, I don't use the word departure, but it's not the typical practice. Typically, I'd get a call that they couldn't reach so-and-so, and the nurse would understand the need to reach somebody in a timely fashion. This is very atypical. This period of time from 11:30 when the patient was in recovery, the calls started, and all the way through 8 or 9 p.m. that night, and no one called me to let me know.
So there is no record anybody tried to reach out to you.
Not to me, no. There are records. The nurse, every phone call the nurse.
No, calling you. There is record, I hear in the testimony, there is record they try to reach nephrology and internal medicine,
Yes,
but there's no record they try to reach you.
correct.
And I'm sorry, so it's a little challenging for the court reporter and to know who was asking the question. So if you would state your name for the record. Is it-
Dr. Asif Mahmood.
Dr. Mahmood. All right, thank you. All right, any other questions from the panel members? And if so, just please state your name.
Okay, I'm done.
All right. Any other questions?
I think that that takes care of the questions to the. I did have a question for the DAG. Is that
All right.
appropriate
Yes.
now?
Yes.
So my question is, the definition of gross negligence is scant care, meaning almost none, which the evidence, it's hard for me to, I mean, there's a lot of care being given here. How does that, and I'm not trying to, I'm just trying to understand where does the allegation of gross negligence, in what respect is that accusation made?
Sure. And I think I understand the question, and so I'm happy to address that, and I appreciate the opportunity to address that. But the allegation of gross negligence in this case arises from the fact that there is no, again, the evidence is clear, and the various experts and respondent agree this is a patient who has a state of health that is susceptible to change on short time periods. And understanding that there was an internist evaluation performed at the beginning of November, understanding that a cardiologist saw the patient the day before the procedure, an anesthesiologist, as is to be expected prior to the procedure on the day of the surgery. There is a lot of stale information that was relied upon to decide to go forward with the December 5th total knee replacement revision surgery. That being the initial internist evaluation, that period of time that had elapsed. Again, the most recent labs for the patient were the November 7th labs that were in the Cedars-Sinai system, but respondent basically assumed, one, those labs were stale, but two, there was an assumption that the cardiologist and the anesthesiologist must have seen those labs because they're in the system. Given this patient's state and given the state of their health and how susceptible they could be to a critical care issue, that was the want of scant care to proceed in the method that respondent did in this case. And I think your earlier question kind of hinted at the concern of wanting labs within 24 hours. Do they guarantee that a negative outcome doesn't happen here? We don't know that, but given the patient's condition, it's what a reasonably prudent orthopedic surgeon would do to get as current a picture as they can of the patient's health.
Right. Any further questions? All right, Mr. McMahon, is the matter submitted for the panel's consideration?
Yes, we thank the panel for their recent consideration, and it was a pleasure speaking in front of you. We submit.
Mr. Mejia, matter submitted?
Yes, Your Honor. Thank you, everyone.
All right, matter submitted, and the record is closed. We are off the record. All right. Thank you, and I will turn it back to Dr. Thorpe.
Thank you, Judge. Are you guys doing okay? Do you need a bio break? I need a bio break.
All right, so are we taking a 10-minute break? Do we know how long we're?
5 minutes.
5 minutes.
5 minutes? Okay, all right then.
Can I ask a quick question before both the attorneys leave?
Oh, yes, I think that if they're still there.
I just need contact information, an email and phone number for both.
All right, Mr. McMahon and Mr. Mejia, our court reporter needs some contact information for you.
Thank you, Your Honor. I'm sorry. I was walking away. I'd be glad to answer anything I can, Mr. Reporter.
Just
I-
contact.
Yeah,
Oh,
just contact, email and phone number is fine.
My email, we just changed, is I'll spell out every letter. R as in Raymond, M as in Mary, C as in Charlie, M as in Mary, A as in Apple, H as in Hollywood, O as in Oscar, N as in Nancy, at sm-lawyers, plural, so lawyers.com. So R. McMahon at sm-lawyers.com. And did you need a phone number?
Please.
949-727-7077.
Excellent. Thank you.
Thank you.
Appreciate it. Mr. Mejia?
Sure. My email address is GIO V as in Victor ANNI dot M as in Mary EJIA, and that's at doj.ca.gov.
And then just a phone number.
Sure. 619-738-9072.
Thank you.
Thank you.
Welcome back after a short break. So we are now moving to our second case for oral arguments this morning. The case of Dr. Leif Rogers, and I'll turn this back over to Judge Larson.
All right, thank you. All right, I need to first make sure before we go on the record that I can hear and see Deputy Attorney General. Is it Ms. Smith?
Morning, Your Honor. Yes.
Right, good morning. And then Dr. Rogers and his counsel, is it Mr. Brenninger?
That's close, Your Honor. Brenninger.
Brenninger. All right, wonderful. All right, in just a moment here, we will go on the record. Mr. Peters is our court reporter. I will announce the oral argument and then have the parties announce themselves. I will have each of the board panel members announce themselves. I will establish a quorum, and then I will explain how the oral argument will proceed this morning. All right, Mr. Peters, just let me know when you are ready.
I'm ready, Your Honor.
Right, on the record. Good morning. We are on the record before the Medical Board of California, Panel B, Department of Consumer Affairs, State of California, in the matter of the accusation against Leif Rogers, MD. This is Physician and Surgeon Certificate number A86603, Medical Board Case number 800-2022-088307. OAH case number 2024-010031. Today is Wednesday, March 14th. It's 2025. It is 10:26 a.m. We are here at the date, time, and location of oral argument and the notice for oral argument after non-adoption of the proposed decision. We are conducting this oral argument in person and by WebEx video conference. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. I'm now going to ask our court reporter to state his name and his CSR number for the record.
My name is James Peters. My license number is 10,063.
And I'm now going to have each of the panel members identify themselves for the record, starting with our chair, Dr. Thorpe.
Richard Thorpe.
And Ms. Lawson.
Christina Lawson.
And Dr. Elia Rodriguez.
Irving Ayala Rodriguez here.
Dr. Mahmood.
Dr. Asif Mahmood.
And Ms. Rimke is not with us today, correct?
Correct.
All right. And then Dr. Yip.
Dr. Felix Yip here. Thank you.
All right. We do have a quorum. I'd now like to take the appearance of the Deputy Attorney General.
Rebecca Smith on behalf of complainant.
And counsel for respondent.
Morning, Your Honor. Matthew Brenninger on behalf of Dr. Rogers.
Good morning. And Dr. Rogers is seated next to you, correct?
Yes, Your Honor.
All right. All right. So the following process and time limitations will apply to this matter. First, respondent has 15 minutes for an opening argument. The Deputy Attorney General will then have 15 minutes for an opening argument. Respondent then has 5 minutes for closing argument, and the Deputy Attorney General has 5 minutes for closing argument. These time limits will be strictly enforced by me. I will be setting a timer, and I will provide a 1-minute notice for the 15-minute opening argument and a 30-second notice for the closing argument. As a reminder, the board has already had the benefit of reading your briefs. The oral argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any of the panel members may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer Dr. Rogers an opportunity to address the panel. If he wishes to do so, I will place him under oath. As you know, we have a court reporter who is present and transcribing these proceedings. So it's important when you're speaking to please keep your voice up and to speak a little more slowly than you would in a conversation. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive a written decision sometime in the future. Right, with that explanation, are there any questions before we proceed?
No questions, Your Honor.
Right. Right, Mr. Berninger, if you would please tell me when you are ready.
Think vinegar. That's the best way.
Vinegar, yes, vinegar, thank you.
I am
helps.
all ready, Your Honor.
All right, you may begin.
Thank you. And thank you for this opportunity to address the panel. We really appreciate it. Panel B should adopt the decision of ALJ Heller and find that there's no cause to discipline Dr. Rogers. There's no evidence that he violated the standard of care, much less the clear and convincing evidence standard which is required to impose discipline. Business and Professions Code 2335, subsection B1, requires the panel to give great weight to the factual findings of ALJ Heller. Basically, this means that there's a strong presumption of correctness in his findings. This legal principle is completely ignored by the complainant in its brief. So let's march through those factual findings, starting with one of the big issues in this case, which was the patient's clearance for the surgery. Now, Dr. Byers was the patient's PCP in this case. He cleared the patient for a tummy tuck and an internal hernia repair. These are major surgeries. He found that the patient was in excellent health and that she was optimized for surgery. Now, the actual surgery that the patient received, in addition to the tummy tuck and the hernia repair, included some liposuction, application of Renuvion, and a short scar brachioplasty. Dr. Byers testified at the hearing that she was in very good shape to undergo any type of surgery, even a lengthy surgery with 9 hours of anesthesia, which is precisely what occurred here. Now, Dr. Rogers' expert in this case was Dr. Peter Rubin. He's the professor and the chair of the Department of Surgery at the University of Pittsburgh. He is a board-certified plastic surgeon, and he is the past president of the American Society of Plastic Surgeons. He has published many peer-reviewed articles in a textbook, the textbook on body contouring surgery. And he was asked for his opinions regarding whether the appearance or the clearance was correct. He testified, and I quote, "Recognizing that Dr. Rogers did indeed perform more procedures than the tummy tuck and the hernia repair, I looked at this note of clearance as with an understanding that abdominoplasty is a very major procedure and that this patient has been cleared for major surgery. And in my opinion, the other procedures added by Dr. Rogers were more minor. When they are put together to the abdominoplasty, they most certainly still represent major surgery, but the patient had already been cleared for major surgery. This clearance, if I was the operative surgeon, would not preclude me from adding additional smaller procedures to the surgical plan." Now, the complaints expert was Dr. Ng. She testified that a surgeon must communicate the exact number and extent and the expected length of the surgeries planned with the PCP. In her opinions and her testimony, she didn't cite any medical literature in support of her opinion, and she has 0 peer-reviewed publications or presentations on this topic, unlike Dr. Rubin, excuse me. Dr. Ng's entire testimony on this and every subject should be disregarded. She wrote 3 different expert reports. She falsely claimed that Dr. Rogers' surgery center was not accredited. She falsely claimed that Dr. Rogers sent the patient to a mere hotel room to recover. Both of these false claims in her 3 expert reports were not pursued by the board because they are factually unsupported. Not only did she include these false claims, but all 3 of her expert reports falsely stated that Dr. Rogers performed surgery on patients' buttocks. That was simply not true, which she conceded at the hearing. Additionally, Dr. Ng, under cross, was forced to concede that she had exaggerated her credentials and her CV. She claimed that she had experience in all aspects of plastic surgery. In fact, she said she was extremely experienced in all aspects. That was simply not true, as established on cross. The ALJ made a finding of fact, which once again must be entitled to great weight, that there was no extreme deviation from the standard of care with respect to the clearance. He agreed that the patient's health was excellent and that she had been cleared for major surgery. And he found it is not necessary to have the exact regime of procedures delineated by the primary care physician if the patient is cleared for major surgery. The PCP's assessment is unguarded, and the surgical plan is consistent with the overall category of surgery specified in the medical clearance. It's the difference between major versus minor. Panel B should adopt these factual findings by the ALJ. Next, there's the question of staging surgeries. Dr. Ng testified that these surgeries should have been broken up into several different surgeries. Like her other opinions, her opinion is not supported by any peer-reviewed literature or any other authorities. She's never published on this issue, nor has she given any presentation. She also fails to discuss in her expert opinions or in testimony regarding the risks inherent by having a patient undergo multiple surgeries. Now, by contrast, Dr. Rogers' expert, Dr. Rubin, has published widely on combining or staging surgeries. He has also given presentations on this topic multiple times. He found that it was safe for these procedures to be combined, especially because it was at an accredited facility and the patient was transferred to a recovery facility where she was closely monitored. His own peer review research found that combining procedures only increase risk additively. This means that combining procedures didn't increase risk for the patients over and above doing them separately as opposed to exponentially. The complainant points out that this study was for massive weight loss patients in a hospital setting, but it does not explain why there's any material difference between those kind of patients and the patient at question here. Regardless, Dr. Rubin's opinion is backed up by his extensive experience, his knowledge, and his impeccable credentials on this issue. In his finding of fact, the ALJ found evidence presented leaves substantial doubts about whether Dr. Ng's opinion, that's the complainant's expert, is correct. The record does not reveal a clear standard about when multiple cosmetic procedures should be staged. And based on Dr. Rubin's testimony, it is unclear if the standard of care includes a definitive time limit that the respondent exceeded. Once again, Panel B should adopt the ALJ's factual findings, which are entitled to great weight on the issue of combining procedures. Air conditioner just went off. Next, there's the question about whether the patient should have received an anticoagulant. Dr. Ng testified that because the patient's Caprini score was 5, that the patient should have received one. Now, Dr. Ng's three expert reports on these issues did not consider at all the risk of bleeding from taking anticoagulants and how you balance that risk of bleeding with the marginal decrease in the risk of a VTE by using an anticoagulant. Dr. Ng's, just like all the rest of her expert reports and testimony, was not supported by any medical literature. Further, she's never published on this issue nor given any presentations on it. By contrast, Dr. Rogers' expert is Dr. Swanson. He has published 38 peer-reviewed articles on VTE, and he has given 40 presentations on the issue in national and international conferences. He is a board-certified plastic surgeon who has performed over 1,000 abdominoplasties and hundreds of arm lifts, thigh lifts, usually in combination. Dr. Swanson testified that the American Association of Plastic Surgeons, which is the leading association, does not recommend an anticoagulant until the patient's Caprini score is at least 8, far more than patient's one's Caprini score. This article, which is found in Exhibit AA in the record, impeached Dr. Ng's testimony that an anticoagulant is appropriate when the Caprini score is only 5. Dr. Swanson further explained during the hearing when he was asked on cross, Doctor, what did the standard of care require in April 22 with respect to this patient? He replied, well, I can tell you what it did not require. It did not require that the patient be put on an anticoagulation. Thus, Dr. Ng's extreme and unsupported opinion is not supported by the consensus standards in the standard of care. ALJ Heller is right. There is no clear and convincing evidence that Dr. Rogers violated the standard of care when he decided that the benefits of prescribing an anticoagulant were outweighed by its risks. Once again, the panel B should adopt this ALJ's findings on the issue of the anticoagulation. Next, there's the question about whether Dr. Rogers should have disclosed the FDA status of Renuvion. Dr. Rogers' expert was Dr. Robert Sade. He's the distinguished university professor and professor of surgery at the Medical University of Southern California. He founded the Institute of Human Values in '94, which is responsible for ethics in developing policies and ethics. He has published over 250 pages on medical ethics, including a book on the topic, and 10 of his papers have been on the ethics of informed consent. Dr. Sade testified that physicians are not required to disclose the FDA status of non-experimental or non-investigative drugs or devices to patients, which is precisely what Renuvion is. It's non-experimental. He also testified that neither the American College of Surgeons statement on principles nor the American Medical Association's Code of Medical Ethics require disclosure of FDA status. Physicians only need to disclose the risk and benefits of a drug and device with their patients, which is precisely what Dr. Rogers did here. The consent form signed by patient 1, which is Exhibit PP in the record, discusses the risks of burns, infections, gas buildup, temporary nerve damage, as well as death. Dr. Ng has 0 medical ethics credentials. Her expert opinions are not supported by any authorities on medical ethics. She has nothing to support her opinion aside from her own subjective experience and personal preferences. This is not the standard of care. Now, there's a legal discussions in the brief about whether California law requires disclosure of FDA status. Not a single opinion has ever held that a patient must be informed of the FDA status of a drug or device. All of the out-of-state authorities, which are persuasive authority, say definitively they do not need to discuss it with the patient. And I think I venture to say that the personal experience of many of the panel members probably have prescribed drugs that are off-label and haven't disclosed that to the patient. They disclose the risk and benefits to the patient. That is what is material. Panel B's factual findings should be adopted. The ALJ should factual findings should be adopted here. Finally, there's the allegation of maintaining accurate records. In its brief, the complainant alleges that Dr. Rogers did not maintain a record showing that the patient's consent that Renuvion may result in serious and potentially life-threatening adverse events. This is directly contradicted by Exhibit PP in the record. Regardless, this allegation didn't even appear in the accusation, and so it's not properly before the board according to Government Code 11503, subdivision A. There's also no basis for discipline for not documenting regarding the FDA approval of Renuvion because there was no obligation under the standard of care to disclose that to the patient to begin with. Next, there's the issue of the DVT worksheet. There was no testimony from Dr. Ng or any other other expert that Dr. Rogers had to document his reasoning why he chose not to prescribe an anticoagulant. Dr. Swanson, who's Dr. Rogers' expert, testified that the standard of care did not require Dr. Rogers to document his reasoning. This makes sense because the standard of care did not require prescribing an anticoagulant. Finally, there's the issue of the operative time where Dr. Rogers said it was a little over 6 hours, while the anesthesia record says it's a little over 7. This was a simple math mistake. The complainant is making a mountain out of a molehill, and the board didn't present any testimony proving that this small discrepancy violated the standard of care. No discipline is warranted against Dr. Rogers for this as well. Thank you.
All right. Ms. Smith, it's now your opportunity to provide opening argument. Please let me know when you are ready.
I'm ready. Thank you, Your Honor.
You may begin.
Good morning, board members of Panel B. Thank you for this opportunity. At the time of patient one's untimely death due to a pulmonary thromboembolism following an elective cosmetic surgery, respondent was about 5 months into his current 5-year probation with the board. After a 4-day hearing and findings that should have properly led to the conclusion that respondent committed gross negligence, repeated negligent acts, and failure to maintain adequate and accurate medical records, the ALJ issued a proposed decision that ignored the clear and convincing evidence and places public health, safety, and welfare at risk. This was an entirely unjustified departure from the medical board's disciplinary guidelines and places patient safety at risk. This was an older, overweight patient. She wasn't medically cleared for the 7-hour and 16-minute surgery with almost 9 hours of anesthesia time. There was no prophylactic anticoagulation given. What happens after this extensive and lengthy surgery? This patient developed a postoperative thromboembolism and she died. The ALJ got it wrong. The clear and convincing evidence established that respondent failed to obtain proper preoperative clearance for the procedure, failed to stage the surgery to minimize operative time, failed to take preventative measures for pulmonary embolism, and failed to discuss the lack of FDA approval for Renuvion for aesthetic procedures. With respect to, first, failing to obtain proper preoperative clearance for the planned procedure. Respondent specifically requested that patient one obtain medical clearance for liposuction of the flanks, mid-back, arms, and axillas, Renuvion to the mid-back, axillas, and arms, fat grafting to the buttocks, and full abdominoplasty. A week before surgery, Dr. Byers, the patient's primary care physician, faxed respondent a medical clearance for umbilical hernia repair and a tummy tuck. Respondent reviewed it. He knew it didn't match his plan. He didn't reach out to Dr. Byers for clarification, and he concluded that the patient was fully cleared. Complainants expert, Dr. Wendy Ng, a board-certified plastic surgeon, competently testified that communication with other doctors caring for the patient is paramount to safe surgery planning and care. Dr. Ng explained that medical clearance for surgery is necessary so a patient is as medically optimized as possible for surgery, so the patient suffers the least risk of morbidity and mortality. Respondents expert, a Pittsburgh plastic surgeon, Dr. Rubin, said that respondent didn't need to follow up with Dr. Byers because hernia repair and tummy tuck is the equivalent to a major surgery. The problem is Dr. Byers thought that hernia repair and tummy tuck would be less than 2 hours. And he testified this patient might be able to handle a 9-hour surgery, but that should be performed in a hospital setting. And this was all after the fact. Dr. Rogers didn't bother to pick up the phone and talk to Dr. Byers about the medical clearance he gave for this patient. And significantly, respondents expert admits that multiple procedures under general anesthesia increase the risk to patients and impacts patient safety. Respondent could have picked up the phone and called the clearing doctor to discuss the surgical plan. Dr. Ng's testimony was clear and convincing. Patient safety is paramount, and he needed to obtain proper preoperative clearance for the planned procedures. Dr. Rogers also failed to stage the surgeries to minimize operative time. Dr. Ng testified when multiple extensive procedures on multiple anatomical areas are planned, the standard of care requires a surgeon to stage the surgeries to minimize operative time for patient safety. There's no urgency to group elective cosmetic surgeries into one lengthy surgery. She explained a single surgery with multiple procedures. The patient will have incisions and drains on multiple body parts, which results in longer recovery and more limits on mobilization. Less extensive surgery promotes early mobilization and safer recovery. Respondents expert Dr. Rubin said it's common to combine multiple procedures into a single operative setting. He had no basis for his opinion other than his personal practice. His research regarding massive weight loss patients in an acute hospital setting. What he does in an acute hospital setting with massive weight loss patients is not what a reasonably careful plastic surgeon would do in the same or simpler circumstances in an outpatient surgical center. Dr. Ng clearly testified for patient safety reasons, there's no urgency to group procedures into one lengthy surgery. Third, respondent failed to take preventative measures for a pulmonary embolism. A pulmonary embolism is a risk to patient safety and health, and it's serious. And here, it was fatal. It was a fatal postoperative complication. Dr. Ng testified that the standard of care requires that the surgeon recognize and reduce the potential of pulmonary embolism, and in this case, anticoagulants should have been ordered. Dr. Ng testified that the Caprini score stratifies risks on a point system. Here, respondent created a DVD prophylaxis order form for his outpatient surgery center. He has it in patient one's chart. He has her name on it. He calculated a DVT risk factor score of 4, and that DVD prophylaxis order form recommendation was anticoagulants if you had a score of 3 or 4. He didn't order it, and he didn't document his medical reason for not ordering it, despite the explicit printed recommendation for it in the worksheet he created and put in this patient's chart. Respondent called plastic surgeon Dr. Swanson from Kansas to testify regarding the use of anticoagulants. He testified that he could not and would not testify to what the standard of care required regarding anticoagulant therapy. Dr. Swanson pointed to a consensus statement regarding anticoagulation therapy, and this is a guideline. It's not the standard of care. Dr. Ng testified that this consensus statement was not the standard of care at the time respondent treated patient one. In the proposed decision, the ALJ improperly substituted his interpretation of this consensus statement for the standard of care. Expert testimony is required, and Dr. Ning is the only competent expert who testified. For safety reasons, the standard of care required respondent consider anticoagulation following a lengthy and extensive surgery, especially on this older and overweight patient, and he failed to do so. Next, fourth, respondent failed to discuss the lack of FDA approval of Renuvion for aesthetic procedures with patient 1. There is no documentation in patient 1's chart that respondent discussed with her that Renuvion was not FDA approved for aesthetic procedures, and that it was not approved for skin procedures, and that it may result in adverse effects. Renuvion wasn't safe for what respondent was using it for, and he should have had a conversation with the patient about it. Dr. Ng competently testified that the standard of care required that a full informed consent by the patient, meaning that respondent should have had a discussion with the patient, explain to the patient that this was there is an FDA warning against its use for aesthetic procedures, so that the patient could have made an informed decision as to whether or not to go through with it. Respondent's expert, Dr. Sadie, a North Carolina retired surgeon, hasn't obtained a patient's consent since 2001. He hasn't used Renuvion. He isn't familiar with the standard of care, and in researching California informed consent, he pulled a California regulation regarding mental health consent in mental health rehabilitation centers, and he applied it to a plastic surgeon providing an off-label use of a device during a major cosmetic surgery. This isn't the standard of care. His opinion is just like the other two defense experts. They must be disregarded. The out-of-state case law regarding FDA status of orthopedic devices in relation to disclosure of material risks of orthopedic surgery do not apply here. Here, the issue is informed consent. Respondent was required by the standard of care to inform patient 1 regarding the non-approved use of Renuvion, and he failed to do so. These 4 extreme departures from the standard of care are also repeated negligent acts. With respect to record keeping, respondent failed to maintain adequate and accurate records of his care and treatment of patient 1. Clinic notes need to be accurate. It's statutorily required, and he failed to do so. He didn't document in any consent forms maintained by patient 1's medical records that Renuvion was not FDA approved for aesthetic procedures. He didn't document any discussion with the patient about it either. He prepared a DVT prophylaxis order. He assessed her risk level as a 4. He didn't order the recommended anticoagulation therapy, and he didn't document any reason why. There's no documentation of any consideration of anticoagulant therapy. He didn't document the surgery time correctly in his operative report. These are all identified in the accusation. And at hearing, there were further illustrations raised of his poor record keeping. Despite being on probation, he still hasn't figured it out. And it should be pointed out that there is no requirement that a medical expert cite medical literature to support her opinions. Dr. Ng competently testified what the standard of care is. The standard of care is a level of skill, knowledge, and care in the diagnosis and treatment that other reasonably careful plastic surgeons would use practicing in the same or similar circumstances. Dr. Ng defined the standard of care. She testified as to what the standard of care required, and she provided a factual basis for each of her opinions. None of respondents' experts testified as to the standard of care in this case. They pointed to their personal practices in situations inapplicable to this case. They pointed to their personal research and publications that are in situations that are inapplicable in this case. Their opinions should be disregarded. Every violation of the standard of care identified by Dr. Ng involved patient safety. Respondent unnecessarily put patient 1 at risk for these cosmetic procedures. He denies responsibility. He's already been placed on probation. Looking back, he wouldn't do anything differently. He completely disregarded patient safety. He can't be rehabilitated. The board has the authority and the discretion to reject the proposed decision and increase the level of discipline. Public protection and protection of public health, safety, and welfare requires the revocation of Dr. Rogers' license. Thank you.
All right. Mr. Penenberg, please tell me when you are ready for your closing argument.
Ready.
I'm sorry, say again?
I'm ready, Your Honor.
All right, you may begin.
Oh, I turned off my mic. Well, now it's back on. Can you hear me better?
I can hear you now. You may
Okay.
begin.
Okay, I appreciate it. This is a tragic case. It's unfortunate, especially in a cosmetic procedure, for a patient to die. But it's also a known complication from this kind of procedure, a known complication that she was fully informed and consented to. Regardless of what Dr. Rogers could have done, in a small number of cases, this is what's going to happen. It is sad, but is not a basis to impose discipline against someone. Dr. Rogers is on probation. He has completely complied with the terms of his probation, which is almost over. He has done his monitoring. He's done his record-keeping courses. He should not be punished by the mere fact that he's on probation. Now, I wanted to point out a couple of facts. First of all, the FDA Renuvion issue. No case has ever held, California or anywhere else, that FDA status needs to be disclosed to the patient. The board would be breaking entirely new ground here if it decided that that was material information that needed to be disclosed to patients. There was no way that Dr. Rogers would have known that that was the standard. It's also, there was no way he would have known about the FDA's warning regarding the use of the Renuvion for aesthetic purposes. It had just been published a couple days before the actual surgery. Physicians can't be held responsible to have an ear to everything that the FDA does, especially in this politicized environment, in the guidance that it subsequently withdrew. Now, Dr. Ng, she wasn't, strictly speaking, required to cite published materials or peer-reviewed materials in her expert reports, but it certainly goes to the weight that should be accorded to them. She provides no evidence to substantiate any of her claims. She does not have the credentials or the background beyond the fact that she's a board-certified plastic surgeon, but that doesn't establish the standard of care. It must be supported by community standards, not just her subjective experience. By contrast, the defendant's experts thoroughly supported all of their claims and showed what they testified were the standard of care. Now, the issue of Dr. Swanson and what he testified as the standard of care, he did testify as to the standard of care, what it was not. He specifically said that it did not require anticoagulation in this particular issue. And this, it's in the record in volume 3 at page 67, I believe. He is not basing his opinions on a simple personal experience. They're based upon peer-reviewed literature that he has published in collaboration with many other eminent physicians in his specialty. The staging issue with Dr. Rubin's testimony, he provides care at outpatient facilities within a hospital. Regardless, he has been a plastic surgeon for years. He is the expert. He wrote the textbook on these matters. He is the head of probably the most well-respected plastic surgery program in the country. There was no one else that was better suited to testify here. Finally, knowing my time is up, I just wanted to talk about the PE once again. The Caprini score, the standard of care, is 8 or more. Dr. Ng's opinion was completely impeached by the consensus standard, which is evidence of the standard of care. And she had no explanation in her testimony why she didn't know it or accept it. Dr. Rogers took PE very seriously. The number one prophylactic thing is compression. And he prescribed compression to the patient and made sure that she was monitored. His treatment of the patient was appropriate and no discipline should be afforded here. The ALJ's opinion is right and it's entitled to great weight. Thank you.
Please tell me when you are ready.
I'm ready, Your Honor. Thank you.
You may begin.
This was a tragic case and it was preventable. He should have ordered anticoagulants for this patient. He had a DVT prophylaxis order form, which states that if you rate a total risk factor of 3 or 4, the patient needs to be on an anticoagulant. He rated her as a 4 and he didn't put her on an anticoagulant. And it is wrong to state that the standard of care at the time respondent treated this patient was that you had to have an 8 or more on the Caprini scale in order to be required to prescribe prophylactics anticoagulants. That's not true, and that was not the standard of care. And respondent, his counsel, and the ALJ are extracting and trying to establish a standard of care from a guideline, a consensus statement. That is not the standard of care. Dr. Ng testified to what the standard of care is, and she did it competently. With respect to the use of Renuvion, he was to inform the patient of the dangers of its use. He needed to be aware of the dangers of its use in his cosmetic procedures. And apparently he wasn't even aware that it was dangerous in cosmetic procedures. That is inappropriate and a violation of the standard of care. And every violation of the standard of care identified by Dr. Ng involved patient safety. Respondent unnecessarily put her at risk for these cosmetic procedures, and she died. He is already on 5 years probation. He hasn't changed his practice or even his manner of documentation. The fact that he's compliant with this probation should be given little weight. He's expected to behave exemplary when he's on board probation. He can't be rehabilitated. He was asked at hearing, looking back, would you have done anything different in your care and treatment of patient 1? His response was, I would not. I've had 20 years of experience doing surgeries of this kind and much more bigger surgeries in the hospital with other type of complications. He didn't even learn from this tragic, unnecessary patient death. Respondent disregards patient safety. The board's highest priority is protection of the public, and revocation is the appropriate remedy here. Thank you.
Mr. Penenberg, does Dr. Rogers wish to address the board members?
Yes, Your Honor.
All right, Dr. Rogers, the first thing I need to do then is swear you in. If you would please raise your right hand. Do And I'm sorry, I'm having a hard time seeing you. There we go. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Right, you may
Yes.
lower your hand. Please state and spell your name.
My name is Leif Rogers. It's spelled Leifrogers.
Dr. Rogers, you may now address the board members.
Hi, everybody. I have deep respect for what you guys do and not a little bit of fear. So I will tell you best I can in my words who I am. I'm a surgeon who truly cares about the outcomes, and when I have a bad outcome, it affects me greatly. This was obviously a bad outcome. I do everything I can to give the patients the best outcomes that I know how to do, both in terms of the result, because I'm a plastic surgeon, I care obviously what it looks like, and that the patients are healthy and happy and all the above. I have years of experience of doing very big surgeries, and her quote obviously wasn't very well spoken by me, the quote, but I used to do many deep flaps and things like that for breast reconstruction. And what I was referring to was, in the past, we used to put everybody on anticoagulation for deep flaps because we were afraid the vessels would clot. And the biggest complications I had were hematomas. I mean, we would have hematomas on every third case. They've since stopped using anticoagulation on flaps like that. In fact, they use essentially no anticoagulation on these giant cases. And these are much bigger cases than I did on this patient of mine. And so part of what influences my decision-making process is that I worry about complications, especially in an outpatient setting where a patient's going to go to an aftercare place and there's nurses there, sure, and she's being monitored, but I'm not sitting there with her and seeing what's happening. So my way of managing these types of cases was to get them up and out of bed as soon as possible and have SCDs the whole time. And of course, have communication. I have a concierge nurses that I send to patients' homes to check on them the next day if they go home, or the aftercare. And in terms of being on probation, not only have I not, what she said about not changing my practice, I've changed it. Like, I don't even know how much more I could change it. I've instituted all kinds of softwares to help have protections and backups so we don't miss anything. I have flags for all kinds of things if there's like allergies or medications that interfere with one another. When it comes to getting clearances, I wanted her to go to her doctor so I could get a good clearance, because her doctor knows her better than some urgent care, which is where a lot of patients will go to get a clearance. And so when he gave me that clearance, she said she was in excellent health. A tummy tuck is the big surgery. All these other things were minor. I mean, a brachioplasty may sound like a big surgery, but it's literally just a little skin nip. And her case went so well. I was so pleased. I called the husband right afterwards and told him how happy I was with it. And when the whole thing happened the next day, literally I was in shock. I was like numb. I didn't know what to do other than I had to do all the right things, which is call the husband and tell him what happened. Sorry. I'm sorry. I've had a hard time dealing with this just because it's such a big deal. I don't know how else to explain that to you. Looking back at that patient, I answered the question, I wouldn't have done anything differently because I don't know what else I could have done differently. I thought I did everything perfectly. Obviously, in retrospect, I would never have operated on her if I knew this was going to be the outcome. I really do the best I can do every day. I guess that's it. Thank you.
Now I'm going to ask our board members if they have any questions starting with our board chair, Dr. Thorpe.
Thank you, Judge Larson. Dr. Rogers, I guess the question I have is why, at one point you were considering staging the procedures, and that ultimately did not happen. Why did you not stage the procedures and opt for a longer?
Well,
It's a long anesthesia. 8 hours it's
a good question.
I mean, I've assisted on abdominal aortic aneurysm surgeries that didn't last that long.
Yeah. Well, there's two parts. First, I want to say that in our community, these types of surgeries are very common. I know many, many people in my community, and many people do the same types of surgeries. Regardless, I originally offered her staged surgery, but she wanted one surgery. And so we actually had removed some of the procedures off of the 2 stages to try to make it safe for her, because I did not want to do everything at once. She actually had several other procedures she wanted to do, but she kind of wanted one and done. And she was, getting ready for some event, and she wanted time to recover. And so I was trying to give her the best I could do in a safe way.
Any additional questions, Dr. Thorpe?
The other question I had was, you obviously had some consideration of anticoagulation because you put an anticoagulation record in her chart. What was the reasoning behind not doing? I mean, why did you even put that in her chart? What was the point of that if you weren't going to give her anticoagulation?
Well, I do occasionally give people anticoagulation if I really feel like it's necessary. However, my trigger to give it may be not as quick as some of the younger surgeons coming out today. And that's because of my experiences. That note, actually, when we had the surgery center, when I put the surgery center together, it's passed everything and we had all the right paperwork, but we didn't originally have that in there. When I had to do all the courses for when I was put on probation the first time, I spoke to the people over in San Diego who were part of reviewing your charts and everything. And that particular doctor had said that it's a good idea to have that in your chart. And we had a conversation about it. And I said, is it something, do I have to give it to everybody? He says, no, it's still up to you. It's a doctor's discretion, but you just for document reasons, you need it in there. So I said, okay, all right. So I put it in there and we started to use it. But I was worried about her because for tummy tucks, hematomas can be a big problem. I've seen complications from other people's, and in residency, we had this one patient who had a tummy tuck and a hematoma, and she necrosed her entire abdominal wall. So these experiences have influenced me in terms of my decision-making process. And I've had this conversation with my colleagues and with other subspecialties about do you feel like this person needs it, that person needs it? I didn't have this conversation with this patient, but I've had that conversation about many other patients. And this was just my general feeling of the risk factor for this patient.
Then my last question is, you said that you do use anticoagulation on some patients. What is the determining factor for you to decide to use anticoagulation versus not?
Well, in the past, it was people who were like 5 or 6, or people who were obese, or people who had a history of DVT or cancer. And I do a lot of work on patients with cancer. And in fact, the cancer thing is a newer thing as well. I did many surgeries on patients with cancer for breast reconstruction. And in the past, we never gave anticoagulation. That was just not even thought of. But nowadays, we've started to do it. So and since this case, I have started giving it a little bit more frequently, simply because I've spoken to some of the younger surgeons out there who say they give it on everybody and they don't have any problems, which makes me anxious too, because these are young kids coming out who have a year or 2 of experience. But I started doing it and figuring, well, maybe I should do that. At least the hematoma is potentially not life-threatening, whereas this is. So I have started doing it more.
Thank you. That's all for me.
I'm now going to ask if any of our other board members have questions. And if you do, just please state your name before the question.
Dr. Asif Mahmood.
Right. Maybe.
Roger, very sorry for the outcome of this case. And these long cases where a lot of people would think that anticoagulation might be the thing, do you ever consider talking to the patient or family, or documenting that you are not going to do anticoagulation, and what is your reasoning to just clarify things beforehand rather than after this outcome?
Well, if that's the recommendation, I certainly will start doing that. I did not realize that that was an important part of it because we do things a certain way for 20 years and nobody ever said you need to have this conversation with every patient and document it. So when patients have certain risk factors, it triggers to me that, okay, they could probably use it. Then I have a conversation. I think maybe you could benefit from anticoagulation, but I don't bring it up with every patient. But if you think I should, I will.
You.
Yeah.
That's
All right. Any other questions from the board members?
Question, Dr. Yip. Thanks all three for coming today. That helps to understand the case. Dr. Rogers, what % your surgery you say per year that would go for like more than 6 hours?
10%? 10%. Yeah.
Any other questions from our board members?
Judge, I think that closes our
All right then. All right then. At this time, Mr. Brenniger, is the matter submitted for the board's consideration?
Yes, Your Honor, and thank you very much for your time.
Right. And Ms. Smith, matter submitted.
Yes, Your Honor, and thank you,
Right.
board members, for this opportunity.
Matter submitted and the record is closed. We are off the record. All right. I'm going to ask Mr. Peters if he needs any information from the attorneys before everyone leaves. Mr. Peters?
Yes, just email and phone number. Start with
For
Ms.
both
Smith.
I
Ms.
missed
Smith.
that. What did you?
Sorry,
start
email
with me?
and phone number, and either whoever wants to start can start.
Rebecca, REBECCA .Smith, SMITH @DOJ.ca.gov. Phone number 213-269-6475.
Okay,
And my contact information is mbrenniger@brennigerlaw.com, and M as in Matthew, Brenniger, BRI, N as in Nancy, EGAR, and then @brennigerlaw.com. Now my phone number is 415-735-6856.
Thank you.
All right. Thank
Thank
you.
you very
And
much.
Dr. Thorpe, I will turn it back to you.
Thank you, Judge. I think we're ready at this point to move from open session to closed session. And we thank everyone for their appearances today and appreciate the opportunity to hear your case. Thank you.